Morning, everyone. We're going to start our webinar. Welcome in just a couple of minutes. Thanks. Morning, everyone. We're going to start up in about 2 minutes. Thanks. Morning, everyone. We'll wait about 1 more minute and then get underway. Thanks. Well, good morning, everyone. We will go ahead and start up our Cal OSHA update webinar. Thanks for joining. You can ask any questions as we go through, either in the chat or the Q&A. We'll be monitoring both of those things. So we have a fair amount to cover. Glad to answer any questions as we go through. And you know all the stuff on this slide. This webinar is being recorded, so members can go to the archive and watch it when they need to, or any of your colleagues who weren't able to attend. It'll be available for them shortly after the webinar. So this is our update. You know me, Director of Risk Management for housing contractors. And we're going to talk about 4 Cal OSHA regulations that are in various stages of moving, shall we say. hold on one sec. There we go. So, two things before we get into the individual regulations themselves about Cal OSHA. First is, you may have heard there's a new United States Supreme Court case called Roper Bright that undid the Chevron doctrine, which was a 40-year-old holding by the United States Supreme Court that limited courts from looking at regulatory agencies and their work. Basically stating the judges and justices have to consider that the agency is the expert and you need to defer to their expertise. And you can really only opine or intervene if they've done something legally wrong. And the new Roper case said very differently than that. Judges are required now to use their independent discretion to review anything brought before them about a regulatory agency. That's a huge change. It's starting on the federal level, and you can know that I am already working with our coalition colleagues in the construction industry to say, how can we implement this in California and push back on California regulatory overreach in its many forms. So, but then we turn around yesterday, Senator Elizabeth Warren filed legislation in the US Senate to overturn the Roper case and go back to the Chevron doctrine. We hope she will be unsuccessful. It would be hard for her to succeed in a divided Congress. So we're pushing forward on implementing the now Roper doctrine, but that'll take a little while. We don't know how far we can go, how big we can go. So we hope that might make a difference on what we're going to talk about today, but we can't bank on that. We need to go ahead as if, Cal OSHA is where it is. And sadly, Cal OSHA where it is not in a good place. They have been pretty much leaderless for the last dozen years, where everybody in their little fiefdom does what the heck they want, and they are not accountable to anybody. So when you see some of the frustrations that you and I and you will both have with these regulations, you'll know we've pushed back hard and gotten some movement and some relief, but not nearly as much as we could. And that's another part of saying that I'd love to say, hey, Cal OSHA regs all enhance worker safety, so be in full compliance. But that would not be correct. Some Cal OSHA regs, parts of their regs do that, but others are just, too overdone, and actually in some places are counterproductive to worker safety. So you will likely, as we're talking this through, see and make risk management decisions and say, in some cases, I will risk a citation from Cal OSHA rather than going all the way with this overdone regulation. So we'll try and point that out. I wish it were not this way with Cal OSHA, but it is a reality. We do want to protect our OSHA history record. Our OSHA history record from our company is never ends. It will be always on the federal OSHA website, accessible by anybody. So we want to limit that. We want to limit repeat violations. We want to try and not be cited by Cal OSHA or defeat their citations, but in some cases you may understandably make a choice to do differently. So understand that caveat as we kind of go through this, and we're going to just do our best. So we're going to start with indoor heat illness prevention. As you know, this has been in the works for 7 years. There was a bill that said we want to cover warehouse workers from indoor heat illness because we only had an outdoor heat illness regulation, and Cal OSHA people said, well, let's not just cover them, let's cover everybody. So 7 years later, 12 versions, which are still screwed up. As you know, we had a webinar in February preparing you. We thought the standards board would pass a regulation in May. The governor's office, the prisons intervened at the last moment and said, no, the prisons can't afford it. So they regrouped it and brought it back in June and passed it and sent it to the Office of Administrative Law, who is supposed to review and approve regulations. And typically that would have meant the indoor heat illness, if it were approved. The Office of Administrative Law, OAL, has 30 working days to approve or disapprove a regulation. They usually get it done before 30 days. So 30 days was today. So we thought that it might be acted on a day or two previous to this, but that they would give us somewhat of an on-ramp to August 1st, August 15, because that's the right thing to do. Normally, if a reg attaches on the next quarter, so it should have been October 1, but they were going to ask for an expedited effective date because summer is here, and we understood that. But what has happened, the Office of Administrative Law did act yesterday. They approved it, evidently effective the same day, meaning yesterday. I was notified of this 7:30 last night, and first thing this morning, the Office of Administrative Law listed it as now approved, where it was not the day before. Nothing has changed on the Cal OSHA website regarding indoor heat illness. So apparently it was effective yesterday, and Cal OSHA inspectors could have cited for it yesterday or today or tomorrow. This is terrible government. It's not just Cal OSHA now, but the Office of Administrative Law. That's a bad idea. So it appears we have not seen the actual confirmation from Cal OSHA, but I saw a colleague sent me information from the Cal OSHA Standards Board General Counsel that they said it was effective yesterday afternoon. So we'll see. It'll officially be done probably during the time we're on this webinar. So sadly, that's how badly our state government is operating. So you see, and the next slide is the text that was sent to the Office of Administrative Law probably within the next day or two. That will be added into a new section 3396 in Title 8 with the final language that will be quote unquote cleaner. But this is what we were dealing with and how we are dealing with it. So what are key issues for us and our members, as we talked about in February? What are the exceptions? What is a when is a worksite indoor versus outdoor? We're used to the outdoor. What's required when there is an indoor workplace versus the outdoor? And how will it be enforced? And the how will it be enforced is a really important question, because the Cal OSHA inspectors are all used to outdoor workplace regulations. So they are likely going to be strongly across the board enforcing this regulation. There's a lot of labor push to enforce this regulation. Thankfully, that's primarily with businesses subject to type 1 and type 2 workplace violence. I'm sorry, we're now on heat illness. I'm already into workplace violence. So heat illness, there's a lot from the unions. Hopefully they focus on warehouses and those kind of people. Hopefully they don't come to us, but we know Cal OSHA does outdoor workplace sweeps during the summer for heat illness prevention. If they show up for one of those, they're going to ask now for our indoor heat illness prevention. And they are going to be ready to enforce it because they already know how we're supposed to be trained. So a lot of similarities with that. The other part is any of us can have an employee have a heat illness. They were unfit for duty. We didn't know it, drank heavily last night or did something else. So this is a problem that we need to be careful of because if we have an employee have a heat illness and it turns serious, especially, they're going to scrutinize our indoor heat illness prevention pretty heavily. So we need to make key decisions about how we comply as we go. So the exceptions, these are important. Obviously, any indoor work areas under 82 degrees Fahrenheit are accepted. I mean, that makes sense. Telework locations of the employee's choosing, not under the employer's control. This should have said telework locations, period. They've added this sentence, which makes it weird because we might have an employee who says, I want to work half the day at Starbucks and half the day at home or something. And we say we don't think Starbucks is a good location, and technically they're no longer accepted. So we need to just carefully figure out how we qualify all of our people who telework to get under this exception. The biggest thing for us is incidental exposures. Cal OSHA has had multiple tries at this and still failed. So they did give us, if there are incidental exposures less than 15 minutes in any 60-minute period. And for this is mostly going to be our storage shed issues and our storage container issues on job sites. So in theory, if it's less than 15 minutes and it's not 96 degrees, we're accepted from being in the indoor heat illness, probably still subject to outdoor, possibly. But the problem is, in California, we get many, many days, our storage sheds and containers are at 96 degrees and higher. So what happens there? We'll see in a minute what to do with that. But the other part they really screwed up was, unless you're in a shipping or intermodal containers during loading, unloading, or related work. Well, their intent, they say, was to talk about warehouses, logistics industries where somebody brings a container in, it's fully unloaded, fully loaded, and on its way. Well, we're not doing that, but if we go in to, we drop off a load of, tools or material or something, is that loading or unloading? And the also problem is just somebody goes in to pick up a box of nails, pick up a tool. How does that work? So we gave them multiple opportunities and options how to fix this. They didn't. So how do we take care of this until we get this fixed? I am pushing to have them change the reg, but that's going to take them quite some time now. So we have three opportunities. You will see, if you go to this link, there's the final statement of reasons. This is part of the regulatory legal package. They have to respond to all comments before they propose a regulation to the standards board members, 7 independent people appointed by the governor. And you'll see this thing is about 230 pages. There are 3 responses to comments that were brought up by either myself or colleagues referencing storage containers, referencing momentary exposures, and that they need to fix the wording. I doubt Cal OSHA is training their inspectors on make sure you know this information. So we're going to have it. Be good to train our supervisors, foremen, superintendents on it, and or our person who might be talking with Cal OSHA on a job site. Because if someone just looks at the reg, they'll say you were in that storage container for 30 seconds picking up something and it was 98 degrees in there and you're in the reg. And we need to have this information that says, no, we're not. The regulatory legal information said a momentary exposure, and they didn't define momentary, but clearly it says it would not create a heat illness exposure. So get those, in writing so you can show a Cal OSHA inspector on site, because that's going to be one of our big challenges. So what is an indoor versus outdoor workplace? As we talked about in February, anything that's not indoor is outdoor and vice versa. Every place in California is one or the other now. But you will see under ceiling, overhead covering, and it's enclosed by all these on the entire perimeter by other physical barriers, whether open or closed. So it is our belief that until doors are hung, a building under construction is an outdoor workplace and not covered by the indoor. So this is important. And now that this regulation is passed, and again, we're confirming if it actually took effect yesterday, sadly, I think that's true. We need to talk with our builders and our door installers and say, sorry, but we need you to hold off hanging doors. Because once you hang a door, if the windows are there, we're stuck. That's an indoor workplace. And now what do we have to do? For this, we have the same basic requirements: written plan, emergency response, heat, climatization, all those things, training. That should not be hard because most of our members have been under the outdoor workplace for quite a while. But we have a couple of things to do. Temperature readings. And this is something Cal OSHA will focus on a lot, is we're supposed to take readings every day. At the time and place they were, we expected the highest temperatures to know we have to protect our employees. And this record keeping, every job site, every day, and we're supposed to keep this for like a year. That'll be an easy mark for Cal OSHA. We can do as we can do with the outdoor heat illness prevention. We can say, and this is something I think we could monitor where we do have, our shop, our yard, our office, etc., where temperatures could rise into the 82 that triggers training, or the 87 that triggers actually trying to do something physically about the heat. We could say, we know when the outdoor temperature is X, the indoor temperatures are going to be this. So we'll just say, we can say ahead of time, okay, the prognostication is it's going to be 90 degrees outside. We know that makes it 87 indoors, and we're triggered with the indoor for tomorrow. We can do that, and there is a requirement to involve your employees and your union. If you are a union, you now get to say, I need to call my business agent and say, do you want to be involved in us, how we set up doing our temperature readings? And we are required, if we're non-union, to involve employees, somehow actively involve employees. So this is going to be something Cal OSHA inspectors will probably emphasize. And so we need to have something in writing that says what we did to try and do that. Sad, but that's part of the deal. Okay, now the hard part, hierarchy of controls. This is standard across many types of regulations, but we are supposed to, when the temperature or heat index, and we need to consider when it's humid or operations inside, maybe a shop, create a lot of humidity. You can trigger 87 degrees Fahrenheit, a heat index when it's like 84 degrees Fahrenheit. So we need to be aware of that. Also, there's whenever employees are wearing heat restrictive clothing, the regs kick in. Most of us probably don't have people subject to that, but we need to be, aware of that. So we have to go through 3 things, and they've structured this very strongly. So this is going to be hard for us, but we need to have documented how we reviewed our options at each of these three levels. Engineering control says we reduce the temperature below 87 degrees, install air conditioning, other types of cooling mechanisms where nobody has to do anything other than turn on the air conditioning and keep it below 87 degrees. And I just talked with someone who's a manufacturer, and their warehouse in real heat gets to about 93 degrees. They install air conditioning and it gets it down to about 89. They're not done, but they have to have done that because OSHA says unless it's infeasible. Things used to say unless it's not practical. Infeasible says you can't do it almost regardless of cost, or that's what some OSHA inspectors presume. So many of us are going to have a real hard time doing engineering controls to bring this down, but we need to have documented that we reviewed what options we had and why they are infeasible. Administrative controls, this is going to be hard for us as well. This is where you do job rotation, start jobs earlier in the day. Some of that's can be done, some of it's hard. We again need to document we considered administrative control options and didn't. And then unless we have reduced the exposure below the 87 degrees Fahrenheit or heat index, we then need to do personal heat protective equipment, cooling vests, things like this. And especially when we're sending, I think, techs into, back to do customer service in a completed building, and maybe or maybe not, we can get, the air conditioning is going to keep it down below 87. We need to do this. But when we do this, and this may be the only thing that really works for us to do, it is now PPE, personal protective equipment, has to be inspected, has to be kept in good working condition, has to be replaced when it's worn out or the employee loses it. So this is a big challenge. But OSHA can be out on job sites today and say, show me what you did with your hierarchy of controls. So as you understandably struggle with this, let me know how that's kind of going. And if there's, because, we will be trying to push back. We have to make changes on the exceptions. We might be able to get some exceptions for certain types of industries where these things are just too hard and infeasible. So that's where we are. I see no questions yet. Again, if you have questions, let me know as we go through, because we're going to jump into lead. And I'll stay on at the very end if we have additional questions you think of as we go through. So lead. This is a very sad thing for OSHA to do, what they've done and how they've done it. We did get a delay in implementation of this regulation to January 1st of 2025. It applies to both construction and general industry, and we'll talk mostly about construction. We need to understand some of us, our shop, yard, warehouse facilities might come under general industry instead of construction, and we might have to comply with both. We'll talk about that a little bit. These are not new regulations. They've taken the current regulations and changed them. One of the keys to this is how will this be enforced? So hang with me here, because you may say, I have no exposure or need to do anything with this. Let's walk through that. So the good news is this is a really complicated reg. Most safety engineers for OSHA are not going to want to deal with this at all. You're likely not going to get employees complaining, I think I'm exposed to lead above the permissible exposure level. So the only people who are likely to pursue this against us or ask us about it or ask for a copy of the reg if they show up for some other thing are industrial hygienists. And the good news for us, less than 20% of Cal OSHA inspectors are industrial hygienists. So that limits the amount of people who would actually pursue this. But if there's any accident complaint, the district manager just says who's available, and they will send out an industrial hygienist to our construction job site. And they're actually going to be looking for this January 1. So if we tried to comply with this reg, and we'll talk about why it's so overdone, that would be really challenging. But I will encourage you to say we should have something, a written program. We should be able to document what we've looked at and why we're dealing with this. So how will this be enforced? Not much, but we need to be prepared with something. As we know, lead in the environment has gone down dramatically in the last 40 years. We've taken lead out of gasoline, we've taken lead out of paint, we've taken lead out of fixtures and material. So you would think Cal OSHA would be saying, gosh, our current regs are fine because we've done such a good job. Sadly, believe it or not, these regulatory changes effective January 1 will reduce the permissible exposure level, which is the level at which you need to reduce employee exposure to if they are exposed over that on an 8-hour time weighted average, from 50 to 10, an 80% reduction with all these minimizing of lead. And they have reduced the action level at which, if your employees are exposed at it or higher, we need to consider what we can do. We need to train, a bunch of other things. That's a 93% reduction, which makes 0 sense. Unless, and there are two options, and we do need to understand this just so you know, how hard am I going to apply myself to this thing? Do I risk a citation? If you believe the scientific people from Cal OSHA, they will say, well, there are studies that suggest harm can happen to people from lead exposure at a much lower level than originally thought. And that could be true, but blood lead levels of the population have gone down dramatically over the last 40 years. And so, you know, what would that be? Lead exposure is tragic. It's terrible. Someone who has lead poisoning, it's awful. We are not discounting that lead exposure, lead poisoning is a bad thing. But so if you just say the Cal OSHA people on their own thought, well, we need to be more careful with lead, you would say, well, if that were true, they would have reduced the PEL from maybe 50 to 30 and the action level from maybe 30 to 15 and see what happens. How could they reduce it this much? I'm not a big conspiracy theorist, but the reality is Cal OSHA has been working on this since 2011. And in 2015, suddenly a new person showed up leading the Cal OSHA staffers, somebody we never heard of before. And he's very serious about lead. And he was there for about 2 years. And he wrote the final draft of this regulation, and then he retired. And when he retired, we found out that for the previous 28 years, he had worked at the California Department of Public Health in their lead unit. Well, we've been so effective in reducing lead, other than sometimes in water, we have to be careful. The lead unit at the California Department of Public Health has really worked themselves mostly out of a job. But if they have something to do now that they didn't have to do before, maybe they all have jobs. This is sad, but this is sadly the most likely scenario, is that the CDPH wants to keep a bunch of people employed. And the best way to do that is to get more employers doing blood level testing of their workers. Because then whenever there is a blood level test done in California, the medical facility has to send that to the California Department of Public Health lead unit. And they have to record it and consider it and then monitor that person for evidently the rest of their lives. So these people have now a job. Continue, sadly. So what are these regulations trying to do? Scare us. We're supposed to panic and say, wow, until we get data assessments, we'll talk about in a minute, we have to provide interim protections. What do those include? A blood level test of all our employees who could be exposed, medical monitoring, possible medical removal, all this stuff. Showers for many of those employees. And they really, I think we're going to panic and we're going to say, oh, I have to do this until we get actual data assessments done. And the question is, and just looking at this list, if we told our employees, okay, we believe you might be exposed at this level, and so you need to go submit to a blood level test. When you do, your name, address, all your contact info is going to go to a state registry. Now, our employees who maybe do welding on the weekend, go to a shooting range on the weekend, and any kinds of other things, are they going to really want to submit to that? Cal OSHA says, well, employees can refuse it. Well, that's not helpful to us very much, but we know it probably wouldn't happen. But then we're stuck with Cal OSHA if they wanted to say, I think you talked the employee out of it. Also, the other thing we would have to tell employees is, based on the regulation, if you have an elevated blood level, we may have to remove you from the job site. And we would have to pay their pay until they go through this process and get medically cleared to go back to the job site. So it's just ridiculous, actually. It's not ridiculous at the current PEL to say we need to do, if an employee is exposed, greater than the current 50, let's do a blood level test. That makes sense, but not at 10 and not with an action level of 2, the way this thing is. So they have put in for construction trigger tasks that tell us we have to do this stuff. Again, just trying to scare us. So you need to be kind of aware of these. They moved a lot into every level you increase, it makes it, you have to do more stuff. But you'll see things, some of us do, some of us don't do with these. And again, I don't think we need to worry about these so much as we're going to make a decision about, are we going, where are we going with our employees? What do we think our exposure actually is? So you can look back on these and see, and then they throw in where we have any reason to believe that an employee may be exposed to lead in excess of the PEL. Well, how would we know? But Cal OSHA inspector will tell you, oh my gosh, if you're doing this or you're next to somebody, I mean, in theory, the way this thing works is if an employee is working on the same job site as someone is doing fabrication or welding, they might be exposed above a 2 action or at or above a 2 action level or whatever. So general industry, if your employees are there, it's less challenging, but still they want to scare you into interim protection until you do the data or exposure assessment. These regulations are monsters. The construction regulation is 38 pages. The appendices, 3 of them, go to page 90. And then from there, general industry goes to page 174. It's just a monster. That's why regular Cal OSHA inspectors, safety engineers are not going to want to deal with this. It's way too complicated. So what do we need to do? Training. I would suggest we do training. Now, training per the reg is just ridiculous. The training outlined in the regulation is the employee has to be trained on the 38-page regulation and all the appendices. One of the appendices is for supervisors. One is for medical people. We're supposed to train employees on that. It's, I mean, bad. But if we do get an industrial hygienist on site and ask, well, what have we done about lead? That we have trained employees in something. So you'll see a website there with options from Federal OSHA, Cal OSHA. I think we're wise to have some training employees about lead so they have an understanding. If we have areas where employees are exposed to lead at any significance, and sometimes, you know, that's around fabrication, welding, doing some types of tasks. The Cal OSHA industrial hygienists will appreciate if we've taken care to have hygiene areas where employees aren't eating next to or around areas where airborne lead could have landed in that area. And can they wash their hands? You see two products listed that are used for washing that take care of lead. You know, we have those around an area that employees can use if they are exposed to lead. Now, the exposure assessment. This is where, in theory, we're supposed to be able to do this and know that our employees are exposed either less than 2 on a given day, or if they're between 2 and 10, that, you know, is there anything we could have done to give them more protection? They're not at the PEL yet. We're there, or are they exposed? You'll see there are a few exceptions, but and sorry, this is so tedious, but I want you to have a grasp on what we are going to do or not. You'd think we would get something from the manufacturers of products. Hey, this is how this typically operates if you're using our solder, you know, or if you're installing our products, because a lot of products can call themselves lead-free, but they actually have a little bit of lead. According to some people, and that's why we're still trying to find out information about this. If you handle steel, steel can create a lead exposure of 2 micrograms, which is the action level. Do we know that? We don't know. So in Cal OSHA, I mean, again, this thing is just way overdone. They said, well, you can use objective data, but not for the trigger tasks in construction. Well, that's mind-boggling. So it would be good if we can either on our own, if we're sizable enough, concerned about it, a group, you know, a council of competitors can get together and say, hey, let's employ an industrial hygienist, have them do some testing and tell us where we land on our exposure. That would be good to have. Then we could know. And or is there objective data out there findable for our specific type of operations, and someone has done anything on a time-weighted average? We'll see. So the deal, and I'm sorry, I did one typo here. On the PowerPoint that was sent out earlier, it said if over the action level, it's actually if at or over the action level of 2 micrograms, we're supposed to do effective training on all. This is where a Cal OSHA industrial hygienist can come up and see no exposure to lead, and they could say, I know over a year's time on one day, your employees are going to be exposed to 2 micrograms, and I want you to have done effective training. In Cal OSHA's effective training, Fed OSHA says you have to train. And that means if you train employees and they sign a document that says I was trained on this, you're done. Cal OSHA says no, doesn't care whether the employee signed it or not. I, as the inspector, can take your employees aside, ask them questions about the training, and this could be 6 months or a year and a half after the training. And if they don't answer my questions very well, I'm going to say your training was not effective, even if you have it documented. This is a challenge. Cal OSHA way oversights for training issues because of this. So that's why I'm suggesting to try and train on the 91 pages of the reg and its appendices is just, I mean, that's going to be a nightmare and probably fruitless. But there are some you can do, a 1 or 2 pager that we effectively trained the employee, and hopefully that minimizes or maybe tells an industrial hygienist, we did our job. Employees are trained. And if it's over the PEL, if you know your employees are exposed over a PEL of 10, you're not going to walk through this reg and figure it out. You're going to need to employ somebody to help you walk through it because it is a nightmare of compliance. But those are the people OSHA is going to be after. And again, you know, in the past it was 50. If they had dropped it to 30, it still would probably not affect any of our members. At 10, with all the improvements made in reducing lead exposure, I doubt. Hopefully our members have an issue, but depending on what you do, you might see about that. And if you do, you're going to have help. Anybody walking through this reg, it's nasty. And OSHA tried to produce a guidance document on the reg for construction. And they sent a draft over to myself and a colleague for a roofing association and said, what do you think? And we said, well, it's a 38-page reg and your guidance document is 28 pages. I don't think that's going to work. So we sent them, this is how you ought to structure this thing. And that was 2 weeks ago. We haven't heard back, but hopefully they give us something more helpful that we can, you know, approach this thing. But we should be, you know, now thinking about, okay, can we do training? Can we think about hygiene? Can we get those things in place and minimize what we hopefully have to do with this thing? So there are a couple exceptions, and this is something to think about if we find out that we have employees who might be exposed above the action level, and it says blood lead testing or medical surveillance is not required under these two things. And you can see we're not above the action level for 30 or more days. You know, we're at a 5 for 20 days in a year, but we're never exposed above 10. That's accepted from blood lead testing or medical surveillance, not the rest, but that's a huge difference. Or you can see someone who is exposed at above the action level maybe for 15 more days, you know, at 5 or 10 for 15, or for less than 15 days, but never above 20. So there's some exception if we do have, for instance, welders, fabricators, who do have days where they're exposed at the 10 or greater. Okay. I'm sorry, the mind-boggling just continues. Workplace violence. We talked about this in February, walked through it. It took effect July 1st. There you see the OSHA information on it. Because again, this is not in Title 8. This is in the Labor Code. For the first time, OSHA is enforcing items in the Labor Code. That's a problem in itself. So we know what's needed: a written program, documented training. That's a huge deal. And there's a log we're supposed to keep, which is a real liability document over time. So we talked about the exceptions, and these are, I think, really important, especially when it comes to what's recorded on the log. Employees, again, teleworking. We're not responsible for that if we don't make it under our control, so to speak. And then this is one that I think we need to take advantage of because, again, the written program is an exposure the log is just an exposure. It's 5 years of every incident. What did we do in response? What actions did we take? And we know, and you know, it's sad, we should have been either totally exempted from this regulation or at least not subject to the log, because we're only subject to type 3 or 4 workplace violence, which is a disgruntled employee or someone in a relationship with an employee who's disgruntled, who comes on site and wants to do harm. those are things over which the employer has no control. That can happen to any employer at any time. So we want to have trained employees how to respond, avoid that, etc. Emergency response. But so we need to know if that happens on our job site, they're going to scrutinize our workplace violence prevention. But that's why where we have less than 10 employees working at any given time and that are not accessible to the public. That's the huge opportunity we have. So, we know some places, especially housing construction, is like we're working on a house right next to a completely occupied home with a homeowner. Do we put no public access signs all the way around? I think so, because this is a big deal. If we have a crew of less than 10, and again, it's a place of employment not defined anywhere else, is that each housing unit, maybe we have 15 employees on site, but there's only 5 in a crew at each housing unit at a time. Is that a place of employment? You're going to kind of walk through that, but especially the not accessible to the public says we are not subject to type 1 and type 2 workplace violence, which is the main goal of workplace violence prevention. And just so you know, where Cal OSHA is headed on this, they are focused. Thankfully, they're type 1 and type 2. They did a workshop. Cal OSHA did July 10, named Workplace Violence Prevention Workshop that you'd think they'd want the public to attend. But they said, this workshop is targeted towards employee representatives such as unions and community-based organizations. The focus of this workshop is worker rights, how to file a complaint, and workers' stories. As such, this event is intended for employee representatives only and is not open to employers, management, or other employer representatives. So this is where, like, the grocery workers in urban settings who've been so upset about what they're exposed to both in store and parking lot, all this kind of stuff. So hopefully Cal OSHA focuses there. But we need to have our written stuff in place. We need to have done the job we could to try to be in compliance. This, yes, is in effect. And hopefully none of us have that violent events that we could not have done anything to prevent and avoid having to deal with this. So now we get to residential fall protection, which is actually a serious problem with federal OSHA. As you know, we have our residential fall protection regs for production, residential framing, and roofing with a 15-foot trigger height. And that for over 20 years. It's worked great. It's clear, it's clean, everybody knows it. Safe. The union likes it. Carpenters Union is totally in support of it. And for 20 years, we had Cal OSHA employees who understood it was much safer than the federal OSHA regs, because the federal regs have a 6-foot trigger height, which basically means they want you to fall protect single story or first story of a multi-story housing unit versus our kicking in at 15, but there's clear reasons for that. The trying to fall protect the interior, federal OSHA says you can use nets, you can use rolling scaffold, you can use all this stuff, which you can't because we do wood frame construction mostly, and you have to brace it. All those things don't work. The only thing to work is ladders, which we are considered by safety people across really the world as the most unsafe thing to do. Try and do actual production work off of ladders. We want ladders for egress and ingress. So 2 years ago, sadly, the last person who defended us at Cal OSHA went and retired. And so we had nobody at Cal OSHA standing up for us, and Fed OSHA began winning our battle. And we have fought this hard for the last 2 years. And thankfully, in May, we made a serious group presentation. We've been doing this at the monthly Cal OSHA Standards Board meeting several times. But at that meeting, we had a representative from Federal OSHA who we had met with several times and would privately tell us, I understand what you guys are doing. I understand it's safer, but the people in DC say no. They want you at 6 feet, period. And it was his last meeting as he worked for Federal OSHA. He then left to one of the federal weather agencies. And I think he actually tried to help us because in front of the standards board members, 7, again, people, regular people appointed by the governor, he talked about, we're not in compliance with their 6-foot reg. And we had made a presentation right before he spoke showing data, how much better Cal OSHA regs are in construction overall, and information from the California Framing Contractors Association about the framing regs and how much better they are. And he said in front of the standards board, we don't care about data. Injury statistics, that doesn't matter. We just think 6 foot's better than 15. And one of the standards board members, while he was still talking, looked up on her laptop the federal website, and she said, your own website says you're supposed to consider data when you promulgate regs. And he said, that's not our interpretation. So thankfully, at that meeting, the standards board members finally grasped why we've had a 22-year battle with Federal OSHA and why their priority is not worker safety. So thankfully, they kind of sent a message to their staff who, again, the current staff has not been willing to battle Federal OSHA. You need to do some battle there. So we got a proposal that went about halfway. The comment date ended July 15. We submitted a letter, coalition letter, asking for more changes that we hope will happen before this has to regulatorily be voted on in November. We are asking for a delay in implementation, as you'll see why in a minute. We need one more set of changes for it to be effective. Here's the current proposal from Cal OSHA. Again, we're pushing back on this. They hopefully will make one more set of changes. We'll see, we'll let you know, but you can see where they're headed. And so what'll happen with it? It expands to all residential construction, not just production. Custom homes, re-roofing and remodels. And the re-roofing industry is going to be in a serious world of hurt because outside production residential roofing, the trigger height has been 20 feet, meaning you don't have to fall protect first or second story. So many re-roofing contractors have never done fall protection. They're now, if this passes the way they want it, they're going to have to do fall protection for 1 and 2 story housing. My gosh, what a crazy thing. So what we are telling Cal OSHA is part of why we're saying there's going to be such a need for fall protection equipment. You need to delay this. And we're asking for at least a year till January 1, 2026. And we hope we'll get that. Obviously, we'll let you know as we get closer to the date. It will require perimeter fall protection for framing and roofing at single story. So production residential roofers will now have to fall protect single story homes. Although many I know of roofers don't do hardly any of those. Most everything they do in urban areas is multi-story, so it likely won't change. But if you're in an area where you're doing a lot of detached single story product, yes, you would have to now fall protect that way. And what we're fighting for is on the interior fall protection requirements for framing. Because again, OSHA says just do it off the ladders, and and we don't want to do that. We think our methods have been better And that's what we want to do. So, final questions. That's where we are. Anything anybody wants to bring up? Sorry, this is unfriendly, tedious, and but we have to navigate through these things because Cal OSHA citations are a big deal, and we need to minimize our exposure to them the best we can. But we're going to make risk management decisions, as you can see, based on all of this. So, and Amy just sent me. Wow, they just sent over. Yeah. At what time? 10:47 a.m. 11 minutes ago. Cal OSHA sent their notice. Indoor heat regulations are approved and go into effect. And there we go. You are the first to know. Thank you, Aaron. This was helpful. Lots of info. Thanks. Sorry. I mean, I wish I could say, man, we're having them redo all this stuff because it's so messed up. But so thanks for that. Any other final comments or questions anybody has? We'll be sending out an alert shortly about the indoor heat. You folks got it even before Cal OSHA sent it. So good luck with this. Please let me know challenges as you go, because part of that is we are pushing back on residential fall protection. We are trying to push back on lead. All these regs we're trying to make less problematic. So yes, from Chris on 6/19, Cal OSHA did a sweep in Palm Springs and had the CSLB with them. Yes. There's a thing called the Labor Enforcement Task Force, and they are a combination of people. CSLB, Cal OSHA, Labor Commissioner, they usually go out. And so we will have Cal OSHA participating in sweeps. And that's why, yes, even though maybe we have very little exposure to indoor heat or workplace violence or lead or something, we can just be in the wrong place at the wrong time. So we have to be careful for that. Thanks, Chris. That's part of our challenge. Anything else from anybody, or we're going to sign off and hope you have a not enjoyable time trying to come up with this, but doing your best. And again, call me for any input you can give on how this is going and so forth. So thanks, everybody. Talk to you soon. Bye now.